Hello and welcome to the Bajirao IAS Academy. So we have been discussing important topics for Polity mains examination, and today we will be discussing about Indian judiciary and some important aspects with respect to Indian judiciary, particularly for the mains examination. And in fact, judicial system is one of the very important topics in mains examination, particularly the judicial pendency of cases, the judicial vacancies, and the memorandum of procedure, judicial activism, judicial overreach. All these topics are very dynamic topics and they are very often in use. So in this backdrop, it is very important for us to understand the judicial system in India in a very detailed manner, so that we could be able to tackle all the questions which are asked from the Indian judiciary portion. And in fact, when we discuss about the Indian judiciary, so Indian judiciary is very often considered as the most powerful judiciaries in the world, right? So Indian judiciary is more powerful than even the US judiciary also. And in fact, Indian judiciary is very often well known as the moral conscience of the nation and speaking truth to the political power that is existing in India. And it plays a very important role when it comes to upholding the rights of the citizens. And apart from that, the judiciary in India also perform several functions. And all those functions of the judiciary that we will be discussing in later stages of this class. But before that, it is very important to understand the provisions in the constitution with respect to the judicial system in India. Now, what are the provisions included in the Indian constitution? And those provisions are considered as very important for the judiciary in India. When we talk about the judicial system in India, the first most important provision in the constitution that ensures independence of the judiciary is Article 13 of the Indian constitution. Remember, this article has been asked several times in the prelims examination. And Article 13 of the constitution, the Supreme Court can actually declare laws unconstitutional which are violation or which are framed in violation of the any of the fundamental rights. However, the power has been given to the judiciary. Judiciary can examine the laws passed by the parliament, and if those laws passed by the parliament are violating the fundamental rights of the people, then the judiciary can actually declare those laws as unconstitutional. So this is the power that has been given to the judiciary under Article 13 of the Constitution. And apart from that, Article 32 of the Indian Constitution. Now, in fact, Article 13 is known as the power of judicial review that has been given to the judiciary. And similarly, Article 32 of the Indian Constitution, it grants certain writs to the both High Court as well as the Supreme Courts. And in fact, these writs are habeas corpus, mandamus, certiorari, quo warranto. So all these are different writs that are being given. There are around 5 writs, as I have just mentioned those 5 writs, right? So those are habeas corpus, mandamus, prohibition, certiorari, and quo warranto. And if any citizen felt that his or her fundamental rights are violated, then they can approach the Supreme Court or the High Court for the remedy of the fundamental rights. And similarly, in Direct to Principles of State Policy that has been mentioned in Part 4 of the Indian Constitution, DPSPs are mentioned in Part 4 of the Indian Constitution. Article 50 talks about separation of the judiciary from the executive. And this is also considered as a fundamental principle that ensures judicial independence. Now, in fact, remember, in Keshwanand Bharati judgment, judicial independence is considered as basic feature of the constitution. It is part of the basic structure. So therefore, separation of judiciary from the executive is mentioned in the Article 50 of Directive Principles of State Policy. And similarly, Article 129 of the Indian Constitution, Supreme Court is known as the court of record, and it also has the contempt power. So what does it contempt power means? So it actually means that whenever the orders of the Supreme Court are not followed by the individual, then the Supreme Court has the contempt power to punish those individuals who are not actually following the orders of the Supreme Court. And in fact, Article 129 has been providing the Supreme Court with the contempt powers. And similarly, Article 131 of the Indian Constitution provides original jurisdiction to the Supreme Court in certain cases. For example, any dispute between center and state government, any dispute between a group of states and the central government, and any dispute between one state and another state. So all those matters comes under the original jurisdiction of the Supreme Court. And similarly, Article 136 of the Indian Constitution talks about the special leave to appeal by the Supreme Court. Right? So this is the article that has been providing special leave for the Supreme Court. And Article 142, and this is also very often in news, and it talks about the power of the Supreme Court to do complete justice in any case. So that is what you have to remember here, the power of the Supreme Court to do the complete justice in any case. And Article 215, it talks about the High Court. So High Court is again has the power of contempt. It has the contempt power, right? Because like Supreme Court, High Court is also a court of record. And even Article 226 of the Indian Constitution, it also provides certain writs to the high courts as well. Now, one thing that we should understand here, the writ jurisdiction of the High Court is much wider than the writ jurisdiction of the Supreme Court. And similarly, Article 227, so it talks about the superintendence of all courts or tribunals which are functioning in its territorial jurisdiction, right? So this power has been endowed to the high courts by the Constitution. And Article 235, it again talks about the control of subordinate courts vested in the High Court. And Article 247, it talks about the power of Parliament to establish additional courts for better administration of the parliamentary laws. So these are important constitutional provisions. Now, remember, whenever you write the answer, so it is always advisable to mention such impactful articles in the answer, because they create good impression to your answer, right? So they will carry more credibility and more legitimacy, right? So there is a chance that you would get a good marks because your answer appears more and more specific. So here you could see the basic differences between the Indian Supreme Court and the American Supreme Court. And very often there is a chance of such questions are being asked in your examination. So what are the basic differences between the Indian Supreme Court and the American Supreme Court, or Indian judiciary or the judiciary of US? Right, like every year there is one question on these differences, either comparisons or differences between India and other important countries' constitutions, the judicial systems, the parliamentary functioning, etc. Now, if you look at the differences, the Indian Supreme Court, the original jurisdiction is confined to the federal cases only. So it has the original jurisdiction only with respect to the federal cases. Now, when I say federal cases, so I already mentioned the cases between the center and states. And any dispute between a group of states and the center, or any dispute between the one state and the another state. So those are considered as disputes under the original jurisdiction of this original jurisdiction of the Supreme Court. Next, American Supreme Court. So when we talk about the American Supreme Court, so the original jurisdiction of the American Supreme Court is much more wider. Now, what is a original jurisdiction? Now, original jurisdiction essentially means that, whenever there is a dispute, whenever there is a conflict between two parties, only Supreme Court has the ultimate right to decide that particular conflict, and this is what is known as original jurisdiction of the Supreme Court. I hope it is clear for you, right? So in India, federal cases are part of the original jurisdiction of the Supreme Court, but in US the original jurisdiction is much more wider, because it not only covers the federal cases, it also covers issues related to naval forces, maritime activities, and ambassadors. So therefore, we could certainly say that the original jurisdiction of US Supreme Court is much more wider than the Indian Supreme Court, right? So we came to this conclusion in the first part. And secondly, Supreme Court's appellate jurisdiction covers constitutional, civil, and criminal cases also. So what does appellate jurisdiction means? For example, imagine that any case is listed in the High Court, and High Court delivers a judgment, and after High Court delivers a judgment, so any aggrieved party can actually appeal before the Supreme Court or before the Supreme Court over the judgment that has been given by the High Court, and that is what is known as appellate jurisdiction. And in fact, the appellate jurisdiction of the Supreme Court actually covers constitutional cases, civil cases, and even the criminal cases as well, right? On the other hand, the appellate jurisdiction of the US actually confined to the constitutional cases only constitutional cases. So we could say that the appellate jurisdiction of US is narrower compared to the appellate jurisdiction of Indian Supreme Court. And in fact, Indian Supreme Court has a very wider discretion to grant special leave to appeal in any matter against the judgment of any court or tribunal. But on the other hand, it has no such plenary power. Special leave power has not been endowed to the American Supreme Court. And in fact, Indian Supreme Court has advisory jurisdiction. Now, what does this advisory jurisdiction actually means? So it actually means President can actually seek the advice of the Supreme Court as well. On the other hand, US Supreme Court has no advisory jurisdiction. So in fact, US President cannot ask for an advice on any issue which has the constitutional importance. So that is another fundamental difference between US Supreme Court and Indian Supreme Court. And in fact, Indian Supreme Court's scope of judicial review is limited. And in fact, the scope of judicial review has been granted to the Supreme Court under Article 13 of the Indian Constitution. However, the scope However, the scope of judicial review is very, very wider in the American Supreme Court. Okay, so that is another major difference between Indian Supreme Court as well as the American Supreme Court. And in fact, Indian Supreme Court defend rights of citizens according to the procedure established by law. Now, one thing that we need to remember here is that we do not have the due process of law. We do not have the due process of law. So this concept is an American concept. However, right from Menaka Gandhi judgment, the Supreme Court has been interpreting various laws passed by the parliament in the light of the due process of law. So due process of law gives importance to the fairness of the law. So law must be fair. However, in fact, Indian judiciary defends the rights of the citizens according to the procedure established by law. From Menaka Gandhi judgment onwards, Indian Supreme Court has also been taking into account the due process of law as well. However, US Supreme Court, it defends the rights of the citizens according to the due process of law instead of the procedure established by law. Now, what does the procedure established by law actually means? So it actually means that a law would be just if it is passed by the parliament, right? So if it is passed by the parliament, the law would be considered as valid and legitimate. So that is what is known as the procedure established by law. However, due process of law believes that the law passed by parliament may be valid or it may be legitimate, but this law should also be fair. And it should not be arbitrary and it should not be discriminatory, and that is what is known as the due process of law. And similarly, the Indian Supreme Court's jurisdiction and power can be enlarged by the parliament. The power has been given to the parliament to enlarge the powers of Indian Supreme Court. So, however, the jurisdiction and powers of the American Supreme Court, so they cannot be enlarged, right? So, in fact, its jurisdiction and powers are just limited to that of conferred by the Constitution. So whatever powers have been given to the American Supreme Court, so those powers are just those are the powers that the American judiciary would have, and in fact Parliament has no power with respect to enlarging the powers of judiciary, and this is in line with the strict separation of powers that we very often see in US political system. And in fact, Indian Supreme Court has power of judicial superintendence and control over a state high courts due to the integrated judicial system. So one thing that we need to understand, so we have an integrated judicial system, and we also understood that this integrated judicial system is a feature of union, a feature that has been indicating a strong union, a strong central government. So along with the integrated judicial system, we also have an independent judicial system, an independent judicial system, a federal feature. However, the US Supreme Court has no such power due to a double or separated judicial system. So they have a separated judicial system, and because of that reason, US Supreme Court cannot actually supervise or superintendence. It has no power of superintendence on the federal courts at the level of states, right? So I hope you have understood the differences between Indian Supreme Court as well as the Supreme Court of United States of America. And now you can also see how the hierarchy is in India with respect to Indian judiciary. For example, so the Supreme Court of India is considered as the apex court, and in fact its decisions are binding on all courts all across India. And similarly, so high courts also deal with cases within the jurisdiction of the state. District courts deal with cases within the jurisdiction of the district, and subordinate courts consider cases of civil and criminal nature, right? So this is how the hierarchy of courts in India at different levels, right? So if you look at the difference between India and UK, particularly the judicial systems, so let's try to understand the differences as well as the similarities between India and UK judiciary or judicial systems, right? So the difference is that there's no jury system present in India, but in UK there is a jury system, and in fact in India this jury system has been abolished. It has been abolished. And in fact, so we have the mechanism of judicial review, and in fact, so we follow the procedure established by law. So procedure established by law. So if any law that has been passed by the parliament is considered as valid and just. So in fact, originally procedure established by law, so that is what we followed with respect to judicial review. But after this Maneka Gandhi case, so we started considering the due process of law as well. So as I have mentioned, what does due process of law actually means? So due process of law means that any law which is fair or fairness of the law. So that is what due process of law talks about. So thereby the scope of judicial review has been further widened, it has been further extended, and you should understand this. But on the other hand, the judicial system of UK, so it relies on the due process of law. In fact, Parliament is considered as supreme and the court does not check the fairness of the law. However, so we could say that the due process of law is virtually absent in UK. It is virtually absent in UK. So that essentially means that Parliament is considered as a sovereign and supreme body, and whatever law that UK Parliament has been passed, it is it actually considered as sovereign. So therefore in UK court does not check the fairness of the law. And in fact, when we talk about the judicial appointments, and collegium system has a greater role of the judiciary, which results in less transparency. But on the other hand, the judicial appointment commission in UK, so that has been given primacy to the Parliament, and there will be rather than greater transparency, so primacy to the Parliament has been given with respect to judicial appointments, right? So, and apart from that, we should also talk about the convergence of judicial systems in India and UK. When we talk about the convergence, so independence of the judiciary, so it ensured through the doctrine of separation of powers in both countries, and secondly, alternate dispute resolution as well. So both countries are discovering alternative dispute resolution mechanisms to improve the justice delivery system, and UK has established a Ministry of Justice in the year 2007. Similarly, India has also started a national mission for justice delivery and legal reform. So these are some convergences in India and UK. So however, this is not that much important for your mains examination, right? So next, what are the roles performed by the judiciary? So how judiciary is very, very important in India. Now in fact judiciary in India is considered as protector of fundamental rights. So it is a protector of fundamental rights that are granted to every citizen under Part 3 of the Indian Constitution, right? So from Article 13 to Article 32 of the Indian Constitution. And here one thing that we need to understand, Article 32 of the Indian Constitution provides for right to constitutional remedies. It provides for right to constitutional remedies. So under this, so we have a set of writs such as habeas corpus, mandamus, certiorari, prohibition, and quo warranto. So these are 5 writs that are granted under Article 32 of the Indian Constitution and Article 226 of the Indian Constitution. So under Article 226, High Court can issue these writs, and Article 32, Supreme Court can actually issue these writs, right? So therefore these writs essentially focus on protecting the rights of or civil liberties of individuals. So in fact, Indian judiciary is known as the protector of fundamental rights or protector of civil liberties of the people. So that have been enshrined in Part 3 of the Constitution from Article 13 to Article 32. In fact, it can restore fundamental rights by issuing writs like habeas corpus, mandamus, etc. So that we have just discussed, and the power to issue such writs has been granted to the granted by the Constitution to the High Courts as well under Article 226. And secondly, the Supreme Court can actually declare any law that has been passed by the Parliament as unconstitutional under Article 13 of the Indian Constitution. So therefore the primacy to protect the fundamental rights has been granted to the judiciary, particularly the Supreme Court and High Court. So therefore these two provisions together considered as most important provisions for the protection of fundamental rights of individuals. And in fact, these two provisions also give power to the Supreme Court to interpret the Constitution as well, right? So Constitution is known as a living document, and in fact, so in India, both the procedure established by law as well as the due process of law has been taken into consideration when it comes to the interpretation of the Constitution or deciding the constitutional validity of any law, or any law or order that has been passed by the executive as well. And apart from that, judiciary is also considered as the protector of the Constitution, savior from the arbitrariness of the government and state as well. For example, imagine that the executive or the state has passed any arbitrary law. It has issued an arbitrary order. So that amounts to violation of the fundamental rights. So in that case, citizens can directly approach the Supreme Court or High Court, right? Because Article 32 of the Indian Constitution provides the writ jurisdiction. It has provided certain writs, and those writs essentially aimed at protecting the civil liberties of the individuals. And in fact, judiciary is also considered as protector of the Constitution because Article 13 has given that power to the judiciary. And in fact, the judicial review of the constitutional amendment, for example, the 99th constitutional amendment, so it talks about the National Judicial Appointments Commission. And in fact, the Supreme Court has declared this 99th constitutional amendment as unconstitutional. So they have declared it as unconstitutional because it violates independence of the judiciary. So since it violates the independence of the judiciary, 99th Constitutional Amendment Act has been declared as unconstitutional. Now, one thing that you need to understand here, the judicial independence is part of the basic structure doctrine. Since it is part of the basic structure doctrine, the Supreme Court has declared the 99th Constitutional Amendment Act as unconstitutional, right? So therefore, Supreme Court actually do the judicial review of the constitutional amendments, legislations of the parliament, and also state legislatures and even the subordinate legislations as well. So similarly, the Supreme Court also have the power to interpret the Constitution, the doctrine of basic structure that has been pronounced in the Keshwanand Bharti judgment in the year 1973. So this doctrine of basic structure doctrine that has been given in the Keshwanand Bharti judgment says that Supreme Court can actually, Parliament can actually amend any part of the Constitution. Parliament has the power to amend any part of the Constitution, but subject to the basic structure doctrine. Parliament cannot alter, change, delete the basic structure doctrine. So it cannot destroy the basic structure doctrine, except that Parliament has the power to change any part of the constitution. And similarly, Article 142 of the Indian Constitution, this is also in news in recent times. So what does Article 142 says? So Article 142 says the power of the Supreme Court to provide complete justice in any case, right? So it talks about the power of the Supreme Court to do complete justice in any case before it. So that is what is known as Article 142. And in fact, so if we discuss in much more detailed manner, so Article 142 actually allows the Supreme Court in exercise of its jurisdiction to pass such a decree or such an order to make it necessary for doing complete justice. So doing complete justice is crux of Article 142 of the Indian Constitution. So there are some examples also. So in 1984 we have seen Bhopal gas tragedy, where methyl isocyanide has killed number of people in Madhya Pradesh, capital city of Bhopal. So therefore Bhopal gas tragedy case, in this particular case, the Supreme Court has ordered the compensation of $470 million to the victims to do the complete justice to the victims. So this is how Supreme Court actually uses Article 142 of the Indian Constitution to do complete justice in any different matter. Now, what is the basic difference between the procedure established by law and due process of law? So that is what we should try to understand here. So what is the fundamental or basic difference between these two things? And in fact, when we talk about the procedure established by law, so this is a British concept. Procedure established by law is a British concept, and in fact Indian Constitution has also adopted this procedure established by law, because we have our colonial legacy, right? So we have our experiences, and because of that particular reason, so colonial legacy or our experiences, we have established procedure established by law. But on the other hand, due process of law belong to USA, right? So it's a principle that belong to US judiciary. And in fact, so what is the basic difference between procedure established by law as well as the due process of law? And in fact, so to test to check the validity of law, both due process of law and procedure established by law would be used to check the validity of the law. Whether a particular law is valid or not is checked through the procedure established by law or due process of law. So let's see how it actually works. And in fact, with respect to the procedure established by law, so it deals with whether there exists a law that authorizes the executive action, whether the legislature had the competence to pass any such law, whether the legislature followed the established procedure to enact the law. So based on this, the validity and the credibility, legitimacy of any law would be decided under the concept of the procedure established by law. But on the other hand, when we talk about the procedure established by law, so along with procedure established by law, it also examines the inherent goodness of the law, whether the law is fair or not. So it actually looks into the inherent fairness, goodness of the law using the principles of natural justice. So here the principles of natural justice would be used to check the fairness of the legislation. And in fact, the procedure established by law, it actually relies on good sense of legislature and the strength of the public opinion, right? But on the other hand, the procedure due process of law, it relies upon the judicial conscience, whether a particular legislation is fair or not, this legislation follows the principles of natural justice or not. So this is what the due process of law actually looks into. And in fact, the power of judiciary with respect to procedure established by law is very, very limited, because so the judiciary can declare laws violative of rights of citizens only on procedural grounds only, but not based on the fairness of the law. And similarly, with respect to due process of law, the judiciary can declare laws as violative of fundamental rights of citizens on both substantive as well as the procedural grounds as well. But on the other hand, one thing that you should understand here, the difference is that the procedure established by law, the Supreme Court can actually declare any law as unconstitutional based on the procedural grounds only. But with respect to due process of law, the Supreme Court can declare any law as unconstitutional based on the grounds of the substantive as well as procedural aspects. And apart from that, procedure established by law, so it an arbitrary action by the state, only executive, not legislature. For example, imagine that in procedure established by law, if any arbitrary law has been passed by the parliament, then the Supreme Court cannot declare that particular law as unconstitutional. But if any arbitrary law or order has been passed by the executive, then Supreme Court comes in and it could declare that particular order as unconstitutional, right? But on the other hand, when it comes to the due process of law, the Supreme Court has the power to declare both executive and the legislative action as unconstitutional, as arbitrary, because it looks into the fairness of any law or any order issued by either executive or the legislature. And in fact, till Maneka Gandhi judgment, we do not have the procedure, we do not have the mechanism of due process of law. So Indian judiciary follows the due process of law only. But after Maneka Gandhi judgment, we started following due process of law as well. So this due process of law emphasizes on fairness of any particular order or fairness of the a legislation as well, right? So I hope you have understood the difference between procedure established by law and due process of law. So the next very important topic is the judicial pendency of cases. So there has been increased pendency of cases in the judiciary. Now we'll understand the reasons for the increased pendency of the cases and what should be the way forward to minimize the pendency of cases. But before that, let's have a look into the data on the pendency of cases, because this is also very important. Whenever you are writing an answer, you always advised to write such data in the introduction, because it could result in a more impactful introduction for your answer. Now, in fact, the Economic Survey 22-23 has been mentioned that as of August 2019, there are over 3.5 crore cases. So there are around 3.5 crore cases pending across Supreme Court, High Court and various subordinate courts in India. So this could be a very impactful introduction and you could include this in your answer. And in fact, so among all these cases, 87.3% of the cases are pending in subordinate courts, right? So this many number of cases are pending in subordinate courts. And secondly, 12.5% of the cases are pending in various high courts across the country, and 0.2% of the cases are pending in the Supreme Court. Now, in fact, a country like India, 3.5 crore cases pending, it is not a small number. So pendency of the cases would delay justice, and it would plague the system as well. So therefore, in this context, it is very important that we should actually reduce the pendency of the cases. So we should also focus on the faster delivery of justice, because it plays a very, very important role in strengthening goodwill, credibility and trust of the citizens on judiciary, right? So these many number of cases are pending across different courts in India. And apart from that, there's also similar data with respect to the disposal time. So the disposal time is 4.4 times in civil cases and 6 times in the criminal cases compared to Europe, right? So compared to Europe, so the disposal time is 4.4 times more, and criminal cases it is 6 times more. For example, imagine that for a criminal case it takes 1 year in Europe to dispose of this particular case, but in India it takes around 6 years. Excuse me. So that is the difference between Indian judiciary as well as European judiciary. Similarly, according to Law Commission, it will actually take around 464 years to clear pendency with present judges' strength. So that also indicates that we have a huge judicial vacancies as well, right? So we also have a huge judicial vacancies, and because of this judicial vacancy also there is a pendency of cases. So one thing that we could understand here is that if we wanted to dispose of these cases in a faster manner, so we should also fill these judicial vacancies, and that is also very, very important. And in fact, justice delayed, it is being said that justice delayed is justice denied. So you could actually go through this data as well with respect to the pendency of the cases, and this data can be mentioned in your answer. And you could also look at the comparison with other countries as well. So how many judges India has per 1 million population, and how many judges the other countries have. For example, France has 124 judges for 1 million population, but on the other hand, India has just 17 judges for 1 million population. So you can mention all this data in your answer to make it more and more impactful. Now we'll understand the reasons for the judicial pendency. Now what are the basic reasons for the pendency of cases or increasing pendency of the cases? Now there are certain reasons. Firstly, the shortage of judges in India. So we have just looked into data that in France, for 1 million population there are more than 120 judges, but in India it is 17 judges. So that indicates that there is a huge shortage of judges. So 419 out of 1080 sanctioned judges posts in 25 high courts are vacant by this particular period of time. And in fact, in India it is less than 20 judges for 1 million population. However, Law Commission has recommended that there should be at least 50 million judges for 1 million population. So in order to reduce the judicial pendency of cases, we should have 50 million judges, but as of now we have just 20 judges for 1 million of population. And similarly, infrastructure is also very poor in India, because just 0.09% of GDP is spent on creation of infrastructure in different courts, right? So therefore this number should be increased. We need to spend more on creation of infrastructure in judiciary, in courts. So that will also leads to better conditions in the courts, and that will also leads to reducing pendency of the cases. And similarly, so we have inadequate technological infrastructure in our judiciary, because we still using the old technologies and old technologies are very often used in the administration of justice, and that increases the time of litigation, and process to adopt new technologies is also slow. So similarly, government litigation, center and states were responsible for over 46% of the pending cases. And summer vacation for judges reflects the colonial hangover also, and rigid procedural requirements, because a lot of paperwork needs to be done on every case, which sometimes creates unnecessary delays as well, right? So apart from that, we do not have a proper investigation mechanism or professional investigation mechanism. So it lacks the modern and scientific tools for investigating different cases, because investigation is very important. Once investigation is done, charge sheet is filed in the courts. So if charge sheet is filed in the court, trials would take place at a much faster time, and conviction would also be awarded in a less period of time. So there is a lack of modern and scientific tools for the investigation, and that has resulted in handicapped police investigation. So these are some problems that are being faced in the judiciary, and that have been lead to increased dependency of the cases. However, what steps have to be taken to reduce dependency of the cases? So a few steps can be taken to reduce the pendency of the cases in this matter. For example, Economic Survey 2018-19 has provided some recommendations. So what are the recommendations that it has provided? Economic Survey has provided, right? So in fact, it has said that there is a need to establish Indian tribunal, right? So Indian tribunal that should be established, and in fact countries like US and UK have already established the tribunals like this. So therefore Indian tribunal should be established for the faster disposal of cases. And 120th Law Commission has also provided some more suggestions with respect to the faster disposal of cases. And in fact, this talked about the ad hoc judges. So ad hoc judges should be appointed using Article 128 and Article 224A of the Indian Constitution. So ad hoc judges will help fill these judicial vacancies, right? So temporarily fill judicial vacancies across different high courts and the Supreme Courts, and it would also result in the faster disposal of various cases. And former Vice President also recommended establishing regional benches in the Supreme Court. So that would also to some extent reduce the judicial pendency of the cases. Now whenever you write the answer, it is very important you keep in mind, so you should mention such things in the suggestions to reduce the pendency of the cases. For example, 120th Law Commission suggested to appoint more efficient and experienced ad hoc judges, and there is a need to establish Indian tribunal and court services like that has already been established in UK and the US, and that has also been giving good results. And former Vice President also recommended establishing regional benches of the Supreme Court, and even increasing court productivity. This is another area that has to be worked on. So increase the number of working days, and a strict codes of conduct has to be provided for judicial officers to ensure adequate performance of the duties and deployment of the modern technologies. For example, National Judicial Data Grid. So this National Judicial Data Grid has been created under e-courts project. So it has been created under the e-court project. And similarly, big data analytics of cases. So big data has to be used in those cases. And similarly, a three-pronged approach has been recommended by Justice Ramana. So Justice Ramana was former Chief Justice of India, and he has recommended a three-pronged approach in disposal of cases or reducing the pendency of various cases. So in this matter, improving judicial infrastructure through use of e-platforms and setting up more courts, and dispute settlement at the pre-litigation stage through counseling, strengthening of the existing alternative dispute resolution mechanism. So this is what former Chief Justice of India N.V. Ramana has been suggested with respect to reducing pendency of the cases. Now, what does this alternative dispute resolution actually means? So alternative dispute resolution, it involves arbitration, mediation, conciliation, right? So all these things are considered part of the alternative dispute resolution mechanisms, right? So for example, setting up lok adalats for the grievance redressal or disposal of cases. So this is also part of the alternative dispute resolution. And in fact, so counseling should be used for disposal of cases at the pre-litigation stage, or settlement of the disputes at pre-litigation stage, and even improving the judicial infrastructure through e-platforms, and also setting up of more and more courts. This is what our former Chief Justice of India N.V. Ramana has suggested. And during N.V. Ramana tenure as the Chief Justice of India, he also suggested that he also established this legal information management and briefing system, which is called as LIMS, right? So legal information management and briefing system. So this is a web-based application that has been created by the Department of Legal Affairs to make legal data available at a one single point, right? So it also leads to the faster transfer of the court orders to the prison officials and other government officials as well. And he also suggested promoting alternative dispute resolution. So as I have already mentioned, what exactly is this alternative dispute resolution mechanism? So it involves arbitration, it also involves reconciliation, mediation, and it also involves setting up lok adalats as well. And for example, nyay panchayats is also part of it. Nyay panchayats and counseling is also part of the alternative dispute resolution. So therefore, pending for 3.5 crore cases can be settled at a much lesser time. So justice can also be ensured, right? So ADR would involve pre-litigation mediation and regular conducting lok adalats, gram nyayalayas in villages that have been established under Gram Nyayalayas Act 2012. And similarly, fast track courts and special courts have to be set up. For example, in order to decide POCSO cases, Protection of Children from Sexual Offences Act 2012, the fast track courts have been established. And similarly, in order to reduce special courts, in order to reduce criminal cases pending against politicians, special courts have been established. In order to reduce the trend of criminalization of politics, special courts have been established to decide cases which are pending against the politicians. So in such a manner, fast track courts have to be established, special courts have to be established to decide criminalization of politics, or politicians or criminal politicians entering into the legislature, and lok adalats need to be set up, gram nyayalayas need to be established, and pre-litigation mediation and counseling has to be provided. So therefore, we need to promote the alternative dispute resolution, and most importantly, judicial appointments have to be made. So there is a huge vacancy across subordinate courts, high courts. So this vacancy has to be immediately filled. So therefore, that would result in faster disposal of cases and reducing pendency of the cases as well. So if there is a disagreement between the government, between the executive and the judiciary when it comes to appointment procedure, ad hoc judges have to be appointed. So we have already discussed about this. So more efficient and experienced ad hoc judges can be appointed in this way. So this also reduces the pendency of the cases in the judiciary. Now we'll understand the judicial appointments. So how judicial appointments are actually made, right? So in fact, what are the constitutional provisions related to the judicial appointments? And in fact, Article 124 Clause 2 of the Indian Constitution, so it talks about the appointment of Supreme Court judges, right? It specifically deals with the appointment of Supreme Court judges. And Article 217 of the Indian Constitution, it talks about the appointment of the High Court judges. And in fact, Chief Justice of the High Court is appointed by the President after consultation with the Chief Justice of India and Governor of the concerned state. And in fact, the judges of the Supreme Court, judges of the High Court are appointed after consulting with the Chief Justice of India, consulting with the Chief Justice of the concerned High Court and also Governor. However, the appointment of the judges of the High Court are made by the President himself, right? So this is how judges of the Supreme Court and judges of the High Court are being appointed, right? So for example, when it comes to the Chief Justice of India's appointment, again, appointment of the Chief Justice of India is made by the President himself after consulting with the such judges President deem fit or necessary for the appointment of the Chief Justice of India. But on the other hand, the appointment of judges of High Court, so how judges of High Court are being judges of the Supreme Court are being appointed. So they are appointed by the President after consulting with the Chief Justice of India, right? So this is how judges of the Supreme Court as well as judges of the High Court are being appointed by the President. Now we'll understand about the collegium system. Now when we talk about the collegium system, so collegium system is actually considered as a committee, right? So collegium system is actually a committee, so that consists of the Chief Justice of India plus 4 more senior judges, right? So 4 more senior judges plus a Chief Justice of India, and it actually takes decisions with respect to appointment and also appointment plus transfer of the judges. It takes important decisions with respect to appointment as well as transfer of judges to both Supreme Court plus various high courts. And in fact, the collegium system is very often criticized. So the collegium system has been very often criticized as it will lead to the mechanism of judges are being appointed by the judges. Judges are being appointed by the judges, and in fact the Constituent Assembly has opposed the concept of judges being appointed as judges because it results in lack of transparency and it also results in lack of accountability in the judiciary. But on the other hand, the judiciary, under the blanket of judicial independence, has been appointing judges through the judges themselves. Now we'll understand what exactly is the collegium system. We have already briefly understood about this collegium system. So collegium system can be called as the mechanism of judges are being appointed by judges, being appointed by judges, right? So this is what is known as judges. This is known as the collegium system, and in fact the collegium system consists of Chief Justice of India and 4 more senior judges of the Supreme Court. So collegium system takes important decisions with respect to appointment and transfer of judges of the Supreme Court plus judges of the high courts, right? So what is collegium system? So collegium system is actually based on 3 judges case. Now when we discuss about the collegium system, we should also understand about this 3 judges case that we will understand going into this lecture further. And in fact, under these three judges cases or under this collegium system, appointment of the judges are made by the Chief Justice of India and four more senior most judges of the Supreme Court, right? So the appointment and transfer of the judges are being made by the Chief Justice of India and four more senior judges of the Supreme Court. And in fact, it has no constitutional backing. Collegium system has no constitutional backing, and it has no statutory backing as well. And in fact, Constitution of India under Article 124, it says that the appointments are being made by the President in consultation with the judges as President may deem necessary. And in fact, critics very often argue that the collegium system of judges being appointed by judges would leads to lack of transparency and accountability in the judiciary. So that is one criticism that has been leveled against the judiciary. However, in 2014, a parliament has passed 99th Constitutional Amendment Act, which is also known as National Judicial Appointments Commission. So National Judicial Appointments Commission is a mechanism that has been proposed by the Parliament for the appointment and transfer of judges. However, the Supreme Court has declared this 99th Constitutional Amendment Act as illegal. It is unconstitutional, because it has been encroaching upon the judicial independence, and judicial independence is part of the basic structure doctrine, and that's why the Supreme Court has declared NJAC as unconstitutional. And in fact, the National Judicial Appointments Commission was a body that was created to end a 2-decade-old Supreme Court collegium system, or the process or the mechanism of judges appointing judges. And in fact, it was passed by Lok Sabha on August 13, 2014 and passed by Rajya Sabha later that day. And it will consist of 6 people, including Chief Justice of India, 2 senior most Supreme Court judges, law ministers, and 2 eminent persons. And in fact, critics say that judges in National Judicial Appointments Commission will need to support of others to push a name through, and they even fear judicial independence being compromised, and that's why the Supreme Court also declared it as unconstitutional, right? So now we'll understand this 3 judge cases: first judge case, second judge case, and third judge case. So through these 3 judges cases, the collegium system has been evolved. Now, what is collegium system? So this is the system through which the judges of the higher judiciary are appointed and transferred. So I hope you have understood this. Now, the first judges case in the year 1981, and this is also known as SP Gupta case. Right, so this first judges case is also known as SP Gupta case. So it says that consultation with the Chief Justice of India doesn't mean concurrence of the Chief Justice of India. It only implies the exchange of views, greater say to the executive in the appointment and transfer of judges to the higher judiciary. Now understand, when appointments to the Supreme Court and High Court are being made, President would consult the Chief Justice of India. Now when President consult Chief Justice of India, so in first judges case, SP Gupta case of 1981 held that this consultation with the Chief Justice of India by the President does not mean concurrence of the Chief Justice of India. So he just consult the Chief Justice of India and take Chief Justice of India's views into account, and accordingly President can decide whom to be appointed as a judge of the Supreme Court and judge of the High Court. So therefore a greater primacy has been given to the executive but not to the judiciary with respect to the judicial appointments in the first judges case. However, the second judges case took place after 12 years in the year 1993. So in this case, the Supreme Court has turned its earlier judgment with respect to consultation. Now in this case, the Supreme Court held that consultation with the Chief Justice of India actually means concurrence, right? So whatever advice that has been given by the Chief Justice of India to the President is binding on the President. However, Chief Justice of India needs to consult two senior-most judges while tendering his advice to the President. And in fact, objections raised by the executive on the appointment, collegium may or may not change their recommendations, which is binding on the executive. So whatever the Supreme Court says is binding on whatever CJI plus two senior most judges say is binding on the executive. They must follow the recommendations of the CJI and two senior most judges. And similarly, in 1998, so this is also known as third judge's case. In this case, CJI should consult four senior most judges of the Supreme Court to form his opinion, and that's how this collegium system has been formed or evolved through the three judges case. The first judge's case, second judge's case, and also the third judge's case. However, a certain lacuna has been existing in the existing judicial system. So what are those lacunas? Now, in fact, the collegium system of appointing judges through judges is against the Constituent Assembly views, because Constituent Assembly rejected the proposal to vest the Chief Justice of India with the veto power over the appointments. Right? So in fact, it is also considered as autocratic because the collegium system is not a constitutional body. It has no statutory backing also. So therefore, the constitution of collegium can be perceived as an act of judiciary to control appointments and transfers in the judiciary under the blanket of judicial independence. And it also results in lack of transparency, lack of accountability, and it also leads to more opaqueness in the functioning of the judiciary, and that is very often considered as undemocratic way of functioning by the judiciary. And similarly, there is no system of checks and balances within the judiciary, because the second judge's case made the Chief Justice of India's recommendations binding on the President. And even the third judge's case has also affirmed whatever the Supreme Court has held in the second judge's case. So this essentially means virtually there is no say to the executive when it comes to the appointment and transfers of judges in the higher judiciary. Similarly, Law Commission in its 230th report, so it talks about nepotism, corruption and personal patronage. So they are prevalent in the functioning of the collegium system, and Law Commission has called this system as Uncle Judges syndrome as well. Right? So however, in 2016, in order to reform the appointment and transfer of judges, so a draft memorandum of understanding has been brought in by the government in 2016. So we'll understand what exactly is this memorandum of procedure. So this a draft memorandum of procedure to set a fresh set of guidelines for making appointments to the higher judiciary, making transfers to the higher judiciary. And in fact, so this memorandum of procedure is considered as a playbook agreed upon by the government and the judiciary on the appointment of the judges, right? So similarly, the memorandum of procedure has evolved as a standard based on the three decisions of the Supreme Court in first judge's case in the year 1981, second judge's case in the year 1993, and third judge's case in 1997. Right? So these three judgments form the basis of a peer selection process for the appointment of judges. So this is what is called as memorandum of procedure. Now we'll understand judicial accountability. Now why judicial accountability is very, very important. right? So what is the need for the judicial accountability? Now, in fact, it is a constitutional duty of the judiciary, right? Because judiciary has the role of guardian of the constitution. It is known as the custodian of the constitution. It is known as the protector of the constitution, and it is also known as watchdog of the rule of law in the country. And it also plays a very important role in upholding rights of people under Article 13 of the Indian Constitution and under Article 32 of the Constitution. So therefore, judiciary is expected to be accountable to the people. And in fact, it is also considered against the constitutionalism, right? Whenever judiciary lacks accountability, whenever judiciary has more and more opaqueness, no transparency, so then it would be considered as against constitutionalism. The principle of checks and balances actually ensures that no organ of the state misuses its power, including the judiciary as well. And to uphold the public trust also, there is a need for the judicial accountability, right? Because recent remarks like asking a rape victim to marry the rapist, prioritizing cases of some people for hearing and delaying others actually erode the trust in the judiciary. And apart from that, for judicial independence without accountability, now judiciary very often talks about the judicial independence, but judicial independence without accountability, so this judicial independence could be used for the personal benefit of judges, right? But not for the protection of rule of law and rights of the citizens. And because of that reason also, judicial accountability is very, very important. And in recent times, rising executive influence is also another major concern because of post-retirement positions on different tribunals and also bodies. And judiciary even enjoys a huge trust and confidence of the people, goodwill of the people, and it is also the responsibility of the judiciary to protect the trust, goodwill that they are getting from the public. So in this context also, judiciary needs to be more accountable and transparent. And in fact, areas where judicial accountability is lacking, there are certain areas where we could consider that the judicial accountability is lacking. For example, the collegium system actually results in the process of judges appointing judges. That virtually, no role for the executive and legislature. So thereby, it is very often criticized for lack of transparency and accountability in the judiciary. And in fact, the procedure under Article 124 Clause 1, Article 217 Clause 1 is a very long and difficult when it comes to the removal of the judges. So therefore, there is a need for the reform in the appointment or removal of the judges as well. And in fact, the conduct of judges, because there are allegations of corruption on Justice Ramaswamy and allegations of sexual harassment on former Chief Justice of India Ranjan Gogoi. So all these things have raised questions on the characters of Chief Justice of India. So therefore, in this context also, there is a need for bringing in accountability, bringing in transparency in the functioning of the judiciary. And in fact, the opacity of the operation, right? Because under the blanket of judicial independence, judiciary actually restricts outside's influence or outside's involvement in the investigation of corruption cases, right? So this also indicates that the judiciary is inward looking and judiciary is not ready to reform the judiciary itself. And information asymmetry is also existing because judiciary is virtually considered outside the Right to Information Act, and Supreme Court rules do not provide a time frame, appeal mechanism, and even penalty for the delay to give information. And similarly, the contempt of court being utilized for rightful critics also. Example, recently the contempt proceedings have been initiated against stand-up comedian Kunal Khamra and even Prashant Bhushan as well, senior Supreme Court advocate Prashant Bhushan. So then also Supreme Court has, the judiciary has been criticized, and judiciary has been criticized for judicial overreach and judicial activism. Particularly, activism towards citizens' grievances has encroached on a line of overreach. For example, national anthem case and highway liquor ban, and in fact, non-declaration of assets by the judges is also another major thing which has been indicating that there is a lack of judicial accountability, right? So in this in this aspect, there is a need for greater accountability in the judiciary. So how can we bring in more accountability within the judiciary? So bring judiciary within the RTI, under the ambit of Right to Information Act, and declaration of assets by the judges is also very, very important. And there is a need to reform the procedure for the removal of judges, and the process of judges, the mechanism of judges being appointed by the judges is also very often criticized for lack of transparency and accountability. And there is also a need to devise a new mechanism for the appointment of the judges. So ultimately, the focus should be on bringing in more transparency and accountability in the appointment of the judges, and similarly the influence or involvement of the executive should also be curtailed, particularly the post-retirement benefits to the judges as governors, as members of Rajya Sabha. So that aspect should also be curtailed. So that's all for today, and tomorrow also we'll discuss some more important topics with respect to judiciary. So thank you so much.